systemic in nature, and coupled with the structural deficiencies in the modalities for the examination, the only course of action which would be permissible in view of the previous decisions of this court, including in, what is that citation? The first one? The citation of Tanvi's case? 2015, including in Tanvi Sarwal versus Central Board of Secondary Education. 2015, 6 SEC 573. And so, 2021, 4 SEC 631 is to order, is to direct a retest. Good stuff. By the interim order of this, by an interim order dated 8 July 2024, while flagging the principal issues in contention, this court had called for a disclosure on affidavit by the National Testing Agency, semicolon, the Union of India, and by the Central Bureau of Investigation. Stop. The role of the CBI has been implicated because the FIRs which were registered in Delhi, Gujarat, Rajasthan, Jharkhand, Maharashtra, and Bihar have been transferred to the Central Agency for investigation. Full stop. Essentially, in the earlier order, this court noted that it would have to scrutinize the following aspects on the basis of the data which would emerge on the record. Namely, 1, whether the alleged breach took place at a systemic level, semicolon. 2, whether the breach is of a nature which affects the integrity of the entire examination process, semicolon, and bracket 3, whether it is possible to segregate the beneficiaries of the fraud from the untainted students. Stop. Direct, consequently issued to the above agencies of the Union to make specific disclosures on the issues which have been highlighted in the previous order. Stop. Arguments have been heard over 4 days. And we have had the benefit of considering submissions urged on behalf of the petitioners, the Union of India, and the National Testing Agency. Stop. Our CBI officer is Mr.
Krishna is Additional Director.
Mr. Krishna.
Yes. Additional
Director CBI has appeared in the course of the proceedings to apprise the court on the status of the investigation. You can say it, Hanu. Arguments have been concluded and judgment has been reserved. Good stuff. In a matter like the present, it is imperative that the final conclusions of the court be disclosed at the present stage, should be recorded at the present stage, since there is an urgent need to bring about the urgent need to provide certainty and finality to a dispute which is which affects the careers of over 2 million students. Stop. The reasons for the ultimate conclusions will follow later, but we proceed to record the essential conclusions in the following terms. Colon. Bracket 1. The fact that a leak of the NEET UG 2024 paper took place at Hazaribagh, the state of Jharkhand, and at Patna is not in dispute. Semicolon. Bracket 2. Following the transfer of the investigation to it, CBI has filed its status reports dated 10 July 2024. 17 July 2024 and 21 July 2024. Stop. The disclosures by the CBI indicate that the investigation is continuing. However, CBI has indicated that at the present stage, the material which has emerged during the course of the investigation would indicate that about 155 students gone from the examination centers at Hazaribagh and Patna appear to be the beneficiaries of the fraud. Since the investigation by the CBI has not attained finality as at the present point of time, this court had, in its previous order, required the union government to indicate whether certain trends in regard to the existence of normalities or otherwise would be drawn on the basis of the results emanating from the 2,750 centers situated with 571 cities. So, pursuant to the directions of the court, the union government has produced a report of IIT Madras indicating position on the basis of data analytics. Full stop. Full stop. The objection of the petitioners to the report of IIT Madras to be considered in the course of the judgment, in the course of the reasoned judgment which will follow. So stop at this stage, in order to obviate any controversy, the court has independently scrutinized the data which has been submitted on the record by the NTH. Semicolon. Bracket 4. At the present stage, on the basis of the material on the record, it is not possible for the court to come to the conclusion that at the present stage, on the basis of the material on the record, at the present stage, there is an absence of material on the record sufficient to lead to the conclusion result of the examination stands vitiated that there was a systemic breach in the sanctity of the examination. Semicolon. 5. Added to the absence of conclusive material on the record of the present stage, the data which has been produced on the record, city-wise, center-wise, the comparison for the years 2022, 2023 and 2024 is not indicative of a systemic leak of the question paper, which would indicate a destruction of the sanctity of the examination. 5. In arriving at the ultimate conclusion, the court is guided by the well-settled test on whether it is possible to segregate tainted students from those whose candidature does not suffer from any taint. Moreover, it would need to be clarified that if the investigation reveals the involvement of an increased number of beneficiaries and those who are suspects at the present stage, action shall be pursued against any student found to be involved in wrongdoing at any stage, notwithstanding the completion of the counseling process. In other words, no student who is revealed to have engaged in acts of fraud or to have been the beneficiary of malpractices would be entitled to claim the vested right or interest in the continuation of the admission in the future. Semicolon 6. The court is also being mindful of the fact that directing a fresh NEET UG test to be conducted for the present year would be replete with serious consequences, some of which serious consequences for over 2 million students who have appeared at the examination, including in particular, Ticket 1, disruption of the admission schedule for the commencement of medical courses. 2, cascading effects on the course of medical education, semicolon, bracket 3, prejudicial impact on the availability of qualified medical professionals in the future, and 4, a serious element of disadvantage to the marginalized groups of students for whom reservation has been made in the allocation of seats. Seven, for the above reason, we are of the considered view that ordering a retest of ordering the cancellation of the entire 2024 examination is neither justified on the application of the settled tests which have been propounded the decisions of this court on the basis of the material on the record. One of the questions in the course of the NEET 2024 was in the following term. वो IIT की रिपोर्ट में आप लीजिए इवन बिलो आ रहा
Yesterday's order.
कल के ऑर्डर में है Initially, the answer key which was prepared by the NTA indicated that the fourth of the above options was the only correct. That the fourth of the options extracted above was the correct answer. Subsequently, on a large number of representations submitted to NTA, a decision was taken to the effect that both the second of the above option as well as the fourth option would be treated to be the correct option. Would be treated to be correct answers. Good stuff. By an order of this court dated 22 July 2024, the director of the Indian Institute of Technology, Delhi, was requested to constitute a 3-member committee to submit its opinion on which of the options noted above would be the correct option, would be the correct answer to the above question. Stop. The Professor Angad, the director and professor of the Department of Energy, Science and Engineering at IIT Delhi, as in his report dated 23 July 2024, indicated that a 3-member committee from the Department of Physics, comprising of colon 1, Professor Pradipta Ghosh, 2, Professor Aditya Narayan Agnihotri, and 3, Professor Sankalpa Ghosh, was constituted for that purpose. The expert team constituted by the director IIT has opined that option 4, as extracted above, is the correct answer. Stop. In order to obviate any ambiguity, option 4, which is to be treated as the correct answer, is set out below in inverted commas. Statement 1 is correct, but statement 2 is incorrect. Stop. In view of the expert determination by the team constituted by IIT Delhi leaves no manner of ambiguity in regard to the correct option, which was in fact initially the only option which was treated as the correct answer by NTA. Full stop. Options 2 and 4 are mutually exclusive and both cannot stand together. Full stop. We accept the report of IIT Delhi. Full stop. Accordingly, NTA shall is the result of the NEET UG 2024 on the basis that the correct answer, that option 4, as set out, as extracted above, represents the only correct answer to the question. Full stop. We have not indicated the number of the question since the number of the questions, since the actual number on different answer booklets, on different OMR sheets, or since the number of the question is likely to vary in view of the procedure which is followed. The number of the question as well as the option is likely to vary in view of the procedure which is followed in the examination to preserve the integrity of the process. The next, during the pendency of the proceedings.
Negative marking your options.
No, we'll just leave it as that. We'll not. During the course of the hearing, the court had been apprised of the fact that NTA would be conducting a special test for 1563 students in supersession of the compensatory marks which were awarded. The students were given an option of either appearing for the special test. The 1563 students were given the option of either appearing for the special test or, in the alternative, opting for their original marks without the addition of compensatory marks. So NTA is permitted to act accordingly following the test which was held. Next. Since the only question which has been, apart from the question which has been, the principal issue which has been urged before the court relates to the sanctity of the NEET UG 2024 examination, whether the process was required to be tapped and a fresh test was to be reconvened. Full stop. Having answered the question in the above terms, it needs to be clarified that if any student, including in the present batch, has an individual grievance not bearing on the issues which have been resolved by this judgment, be open to them to pursue their rights and remedies in accordance with law. The competing high courts, the jurisdictional high courts, under Article 226 of the Constitution. Full stop. If any, however, before moving the High Court for the grant of relief, the petitioners would have to seek the withdrawal of their petitions before this court, if they have been filed. Full stop. Then we'll finally say during the course of the hearing, the court has been apprised of the fact that the Union government has constituted a 7-member expert committee chaired by Dr. K. Radhakrishnan. Radhakrishnan is the former director of ISRO, former director of former chairman of ISRO. Stop. The committee will abide by the committee and consisting of the following members will be clear now. The committee will abide by such further directions as may be issued by this court in its final judgment and order in regard to the areas which should be inquired into by it, so as to ensure that the process of conducting the NEET, UG and other examinations falling within the remit of the NTA is duly strengthened, so that the instances which came to light during the course of the present year are not repeated in the future.
There were some transfer petitions filed by NTA on this issue itself. They steps followed disposed of them.
The transfer petitions raising the issue as regards the validity of the NEET Guruji 2024 examination shall stand disposed of in terms of the above direction, subject to the clarification that individual grievances, if any, that remain, may be addressed before the complete before the jurisdiction.
Let us say not grateful for the patient hearing.
Thanks.
So grateful.
Sorry?
In fact, I have only filed an because tomorrow counseling will start.
The IAs raising individual grievances are similarly permitted to be withdrawn.
Yes, ma'am.
Liberty. Observe this.
Yes.
Milord, a small mention, Milord. Milord, a small mention with great respect. Milord, this is regarding item 21.24. I may be allowed to withdraw my petition, Milord, because it has been tagged with Vanshika Yadav, in which the broad arguments have been addressed.
Anybody else who is present here and who wants to withdraw their petitions, just come and tell the courtmaster, apart from 21.24 who's online, he'll just record it and we'll make sure that is withdrawn, so that there's you don't have to move another court, another time. Just do it right now so you can move down.
I'm so much grateful, Milord.
One point, please, the report may remain for your perusal. Otherwise, we can apply for certified copies. Inspection of certified. Your Lordship may need it, Milord, for judgment writing.
So after the judgment is delivered, then we'll return it back to you.
Yes, in the meanwhile, parties can apply for inspection or certified copy.
Of the CBI report. So the CBI report will be maintained with.
Yes, that's all applicable.
Because it's an investigation report. Otherwise, the whole investigation may be derailed if we disclose it at this stage.
Well, can I, the Lordship says it's not right time to mention. Item 6 and 9 I'm mentioning.
Yeah.
These are the two matters. 9 is Shiv Sena, 6 is NCP.
Yeah.
The Lordship had intended to have it urgently here, but NEET overtook us. Lordship give us the shortest possible time.
I appear for the respondent.
I'm asking for the shortest possible time. There is 9th, otherwise the thing is completely infructuous. One way or the other, elections are there.
Volume 4 SCC 631. I'll not read.
2021.
Volume 4 SCC 631. This was also use of unfair means. My lords were pleased to, my lord, consider the case law on the subject and, my lord, observe at page para 56. And I would rely upon respectfully on the last part, but I'll read that para. The decision in railway recruitment, etc., all go to emphasize that a recruiting authority is entitled to take a bona fide view based on the material before it, that the entire process stand vitiated, as a result of which a fresh selection process should be initiated. The integrity of the selection process cannot be lightly disregarded by the High Court, substituting its own subjective opinion on the sufficiency of the material which has been taken into account by the decision-making authority. Undoubtedly, fairness to candidates who participate in the process is an important consideration. There may be situations where candidates who have indulged in irregularities can be identified, and it is then possible for the authority to segregate the tainted from the untainted candidates. Now, please note this, my lords were pleased to say this. On the other hand, there may be situations where the nature of the irregularities may be manifold and the number of candidates involved is of such a magnitude that it is impossible to precisely delineate or segregate the tainted from the untainted. A considered decision of the authority based on the material before it, taken bona fide, should not lightly be interfered in the exercise of powers of judicial review unless it stands vitiated on the grounds of unreasonableness or proportionality. And, my lord, the decision-making process, my lord, I have shown to your lordships, it matches pan-India. There is no spurge. It matches earlier year and the year before that. And even the investigation suggests a localized, identifiable irregularities. And therefore, your lordships may not, Lord, exercise the judicial review. That's the respectful submission. Last, my Lord, the question, my Lord, that wrong and right question. My lord, I have also received several mails from unknown people, and I don't wish to rely upon it, but the common thing, my lord, common thread which is coming is that there are old books which are available. The old books contain a wrong answer, but in the of NCERT book.
But your instructions say that students must go by the latest edition.
No, my lord, the instruction says that in case of dispute, both the marks to be counted. Guidelines, my lord. Give me the guidelines, sir. Yes, sir. My lord, page 70 of my affidavit in Vanshika Yadav.
Yeah, there's one correct answer here. How can we have, and you know, the thing is, option 2 and option 4, there may be a situation where the question is ambiguous and possibly both may be correct answers, logically speaking, in a given case. That you have 4 options. Option 2 may possibly be a correct answer, option 4 may also is really the correct answer, but option 2 is also so ambiguously framed that it may also be correct. In a given example, here, if you look at the answers, each of them excludes the other. Each of them excludes the other.
Let's see, I'm just making an attempt.
Let's just see that.
If your lordship sees the question, my lord, for a second, it's a trick question, my lord. I won't say, my lord, it's a ambiguous question. It's a trick question.
Yes.
Statement 1, I may not read. 2, again I may not read.
Yes.
Now see the question. In light of the above statements, choose the most appropriate answer from the options given below. No, not the correct answer. Which is the most appropriate? There, my lord, possibility of 2 and 4 both being correct.
But see, the item option 2 is both statement 1 and statement 2 are correct. 4 says statement 1 is correct, but statement 2 is incorrect. So both can't coexist together.
I understand. One rules out the other. My lord, I cannot defend, my lord, something which is not. But, my lord, kindly appreciate, my lord, the wrong answer published by NCERT book since years.
Now, just for factual clarity, the wrong answer is option 2. We are taking it as option 2, though in our order.
It may be.
We will just mention. We'll mention the question because you know the question number etc. may be jumbled.
Yes.
So I'm not sure the options are jumbled also. Options may not be jumbled, right?
Option.
Right. So we will just so that there is no.
Better to quote the.
We'll just quote the question. Now tell us one thing. What the option 2 appeared as an answer in which NCERT edition?
Yes. Lord, that appeared.
Your Lordship, prior to 2019. In 2019, the edition has been changed.
No, my lord, that appears to be not a very correct information. My lord, my information is up to 21, it continued. But subject to, my lord,
Your Lordship,
my lord, if some student can come, my lord, the old question, old wrong answer, till what time it continued in NCERT? Till 22. Yes, well, the revised edition came in November 22. One of the students wrote me a mail that before that we have already started preparing.
Your
Revised
Lordship,
edition came in.
what Mr. Tushar Mehta is saying, what my case is, I started preparing in 9th grade itself, from 2020 onwards. So I bought all these books in 2020 itself. I have a copy of edition in my petition I have annexed. That 2019 had the same statement, which was revised in 2019 October, and thereafter in 2023 as well. The same statement has come into being.
I think what we should do is, we should not go by the edition and all that. We will go by the correct answer. Now, suppose let's take an extreme case. Let's take a case where the latest NCERT edition gives a wrong answer. But a student who has prepared well gives you a correct answer. Will we give that student?
I get what your lordship is calling from you. But
IIT tells us what is the correct answer.
Lordship, the IIT have correct knowledge on the subject matter, your lordship.
only a minute,
Yes,
ma'am.
yes.
So at the same time,
Yesterday we referred it to IIT with your consent ultimately.
no, I consented, not.
Let's
But
go by the IIT. They are
the respectful submission is this, and I leave it at that those who relied upon an authorized text of NCERT and given the option accordingly, should also not get the disadvantage of it.
No, Mr. Mehta, the question here is not about the correct question, rote learning. You have to have the fundamentals clear. So far as an unstable atom is concerned, it has to be a radioactive element. Then it becomes unstable. Otherwise, protons, neutrons.
I am not joining issue.
So being a science student, I'm a little bit aware of it.
The matter is,
The answer is so clear. If anybody has his fundamentals clear, he will answer it. So if he is found only reading textbooks which are incorrect, he will render incorrect answer.
And though we gave the director time until 12, before 10 o'clock we had it on our table report.
would not have taken more than 2 minutes.
It would have taken probably 10 seconds to answer the question.
But the persons who will be affected would be around 4,22,000.
Your lordship, but that also has to be considered. How many of them are within 1,08,000, your lordship?
No, everyone would be. They may come, they may go out. We do not know how will.
Your lordship, the inflation itself is the big bug in this entire examination, your lordship, due to only this question marking. Oh, 290, 256 or something.
I tell you.
Was given by 9,28,379 students. So the larger proportion were all giving the correct answer. Option 2 was given by 4,20,000.
Your lordship, the challenge was made by less than 0.6% of students who challenged this question.
Basically, without going into which answer is correct, treating 4 to be correct. only one last request. Only one last. My lord, question number 4 is the correct answer.
Wait till for you to wrap up for a minute. We'll not close your argument right now. Let's just hear.
Yes.
That's the perspective of students. That others are who lose, who stand.
Your Lordship.
So let's see what. Don't just keep your thought with you.
Yes.
There you are.
Can we circulate a note? The main argument here is this applicant. She is AIR 1. She is scoring 720 out of 720. While attempting this question, she was faced with two situations. There's a tabular chart on the second page. If she would not have attempted the question,
She is rank number 1.
rank number 1, 720 out of
720 out of 720.
Yes. If she would not have attempted the question, it would have been -4 for her. So she would have ended up scoring 716. If current situation is executed, now if the current choice is treated as incorrect, that will be -5 for her. So this will be 715. So now she is in a peculiar situation where she will end up getting even lesser. If she would not have attempted the question, she would have been at 715. Because the second difficulty is that in the information bulletin, there is no whisper at all of the fact that there's some new NCERT book which is to be referred. And the old NCERT book is very well on the website also. Because we have made an argument that the rules of the game cannot be changed in between. If my lords may see one judgment, 2011-10 SCC 51. That's the rules of the game, if I may just read the relevant part.
Instruction that if there is a dispute regarding the answer, then the answer given in the NCERT will be treated as correct. Is there any instruction of that nature?
Well, as per...
No, is there any such instruction? No. So the answer has to be correct on principles.
This very one more thing very sorry. But one very important thing in the FAQs which they released post declaration, what do they say? This was also done as a policy mentioned in the information bulletin of the NEET UG 2024. That is, now see, this is very important. If more than one option is found to be correct, then 4 marks plus 4 will be awarded to only those who have marked any of the correct options. So this applies in a situation where 2 answers are found to be correct. If 2 options are found to be correct, then if you adopt any one of them, you will get plus 4. This is not a case where option 2 is correct. Only option 4 is correct.
Well, we are saying that as per option, there are 2 options which are jumbled in each set. So if both statement 1 and 2 are correct, and the today's version of the answer, as per this expert opinion, either or will be treated as correct if there is an ambiguity. Because our respectful submission is that if in case of this ambiguity, if now
that's saying that she will make it to AIMS Delhi.
Yes.
She will not go to AIMS Delhi, but somewhere. You take it from us that we are as sympathetic as anybody else. So we realize that, but it's not a situation where there's an element of ambiguity also. You see, there's not even an element of ambiguity.
My lords, may I just make a ambiguity is in the information bulletin. And in fact, this book is still now it's on the website. The ambiguity lies there that if there were instructions and this applicant.
That's still on the website, is it?
Or even civil services examinations, the students rely on NCR. It is considered to be standard. My Lord Justice Mishra is right. There is no instruction
Argument
that you can read only NCR.
Right. Go back to the solicitor to wrap up.
Yes. My Lord, just the argument on principle. Let's assume that we don't want anyone to be disadvantaged. My Lords, we want to consider what might be an overall solution over here. My Lords, we're testing a competitive exam. We want to test everyone on the same basis. The version of keeping this the same, the best way would be to remove this question at all. Because then what happens is that in a competitive exam,
who didn't answer it.
Your Lordship, the candidates who have answered it wrongly will be benefited of that negative marking, Your Lordship.
No, they won't get the negative marking. That's the advantage. Anyone, the negative marking won't affect them then. That's the advantage. No, the question is removed.
Just talk to your directors here, right?
Yes.
You can ask him, we'd like your assistance on this. What if we do this? See, with the IIT report now, it's staring us in the face. Now, can we in our order, assuming we are not setting aside the whole exam, if we are setting aside the whole exam, all this is irrelevant. Then of course the whole exam goes. But assuming that they are wrong and assuming you are right on the whole exam, we will take a call out shortly. What if we say that only option number 4 will be the correct option, but for anybody who answered option 2, there'll be no negative mark?
It appears to be.
What do you think? Just talk to Dr. Kamakoti and the director.
No, he is the director, IIT, my lord. Your Lordship wants me to...
So just I'll talk to the director, NT also.
NT. In this regard, can I make a submission, Lord?
This one. I will get you.
But I am for a petitioner wherein one student has scored 720. 4 is correct. Obviously. 720 and he has selected option 2.
You have selected option. Like Tanvi.
Like, so my lord, what I am informed that they have purchased the books in June 22. Till June 22, the same book was there which was having the option 2 as the correct answer.
That's why what we are suggesting is that we will not give an additional negative mark.
But 4 marks. I think, my lord, it's reasonable, my lord, with profound respect, my lord. Lordship may ensure that it does not become a precedent. Otherwise, for every question, there can be a litigation, and I am appearing in some of the matters, my lord, where, no, not in this exam, their questions and answers are disputed.
Each mark.
If there is this exam is for elimination and bringing out the best student for the best profession in the country, Your Lordship.
That's what I
Anything more? Anything more? Or you?
No, only one, my lord. There was a not faint but attempt to allege bias IIT Director Madras. We have filed an affidavit that he has never attended any of the meeting. He is member of the general body of NTA.
IIT Madras is a member of the general body of the
General body which takes a policy call, not
coordinating the exam this year.
no, it has nothing to do. But in any case, he asked somebody else to come. We have a composition where whichever.
You said Gopal Krishnan had come.
Yes, we have filed an affidavit to that effect. Kindly take that on record. And what we do is, as per composition, whichever IIT has organized JEE exam last year is our member to gain their experience. So last year was IIT Madras, therefore he came. Our affidavit, my lord, is.
the
He
same.
attended only one meeting, I'm sorry, I stand corrected, in December 22. For general body meeting for overall accounts, etc., not for conducting exam.
Yeah.
My lord.
But I'm appearing for a petitioner. There are 56 petitioners from Gujarat. All are right students. So what I've tried to do is I've shared one written submission yesterday.
So you have all got, how many have got 720 out of that?
721.
You don't want a retest, you want a retest.
We don't want to do.
You don't want a retest.
Most of the petitioners have been selected, but they have scored more than 650 votes. And I'm also appearing for 6 intervention applications wherein 50 applicants are there. Out of those,
They've heard that now the solicitor has argued for your line of.
it's only 1 point. But we have everything, the data and the facts are before my lords. The only thing is that we have tried to make a written submission where we have tried to establish the background of all those candidates.
That's all right.
10th, 12th and everything, because they
You're
are
not saying.
consistent.
Well,
It's not only
you
NEET.
can't go into individual background because.
So that's what I'm trying to say is that not only NEET they have performed well, but there is an exam of good set. Even in those exams they have topped.
Fair enough. Yes, Mr.
My-
Wait, please, Lordship.
My lord, if
Yes, ma'am.
On a
Yes. Sir, I have a very limited purpose, sir. I seek to represent students belonging to tribal, rural, and basically remote areas and EWS categories from Madhya Pradesh. They are being represented by a socially minded teacher. She's a medical professor, sir. Sir, the issue here is that we face is that these students, some of them come from very remote areas, some are even Naxal regions. For them to access an exam center or even sit for a test once is a very expensive exercise, leave alone doing it again. Some of them have even qualified and they have been seeking assistance from professors and guidance during the ongoing litigation. All we request is that if a retest is ordered, these students may kindly be either exempted or some sort of exception may be made for the process to be eased for them, sir, where their prior scores may stand in case.
Ma'am, if we order a retest, we can't create an exception. Then logically we will be incorrect.
My lords,
Either we do it, we have to use the same yardstick for everybody. The fact that there may be students like your candidates coming from tribal areas, those students will have to go through the entire process, may be a ground not to order a retest. But if we order a retest, then we can't start creating any exceptions. Then there will be our judgment will be very vulnerable. We then have to apply one cut across there.
my lords, in that case, I seek my lord's permission to assist my lords.
Therefore, your first point that this may, we take it as a point that, ordering a retest
Sir.
will substantially prejudice students, especially students coming from the poorer backgrounds, marginalized backgrounds,
Sir.
like your class. That point we took.
Sir, with your permission, if I may put forth my lord's observation in Sachin Kumar versus DSSB, which learned solicitor presented. So basically, by your lordship's principle, these students are obviously not beneficiaries of any paper leaks. And if they are put on the same yardstick as the wrongdoers, then it will be a violation of Article 14. That is my lordship's observation in the matter. And such an exception has been made by the Judicature of Patna in Bihar STET leak failure.
Because then you belong to, say, tribal students. There may be Dalit students. There may be OBC students who also come from a very underprivileged background. Then where do we draw the line? There may be disabled students. Drawing a line becomes very difficult for the court, becomes a little arbitrary. So,
I would seek your consideration.
We've seen your first point. We'll
My lords.
take it.
Oblige.
Thank you. What's your name, ma'am?
Tanushri Bhalla. Oblige.
With Your Honor's permission, may I just make a submission? Your Honor, I will take less than 10 seconds. I am appearing in IA number 140274 of 2024 in the lead matter. My Lord, I adopt the submissions which have been made by other contestants. I am also appearing for an applicant who has secured 658 and he is opposing the conduct of re-NEET. He opposes scrapping of the exam. The important thing why I am addressing the Honorable Court is, my Lord, that there have been instances where unsuccessful candidates have approached high courts, sought orders against the NT, and the high courts have judicially determined that such prayers are being made on the basis of forged and fabricated documents. And in my IA, my Lord, I have appended the order passed by the Honorable Allahabad High Court on 18th of June. When a petitioner approached the High Court, he sought scrapping and all those reliefs, stay of counselling, The NTA appeared, produced original documents of the candidate, and it was eventually then the petitioner's counsel sought to withdraw the petition. And the High Court was kind enough not to penalize the student for filing fabricator. So, my lord, the only submission is that this entire exercise, bona fide students are suffering. And some...
Thank you. Lord, yes, basic principle which has been laid down by this honorable court is, if there is a leak, Lord, in this case, leak is admitted. If after the leak,
Be excused for 10 minutes.
Yes.
Lord, after the leak has happened, and the leak was done by the gang head, Lord, who has not been arrested, Sanjeev Mukhia. What is there in public domain, the CBI has not brought it on record. This Sanjeev Mukhia, who is yet to be arrested, is involved at least in 5 major paper leak cases in UP, Haryana, Rajasthan. These are the news items. It is to be verified by them. He has not been arrested. The moment, Lord, it is established that leak has happened, dissemination is through WhatsApp mode. The handiwork of a gang operating in... Now, Government of India taking a firm stand that the leak is now, the beneficiaries of the leak are confined only in Hazaribagh and Patna. And this confidence emanates from only and only one fact, that the accused in custody so far have said that the leak is confined to Patna and Hazaribagh. Patna police, when records 161 statement of the accused, they talk of leak prior to the date of examination. This is also 161. Subsequent 161 statement recorded by CBI probably indicates that the leak is on that date of the examination. Now, Lord, when the CBI officer was talking to this honorable court, his expression, as I could gather, was that so far we have not been able to recover the mobile phones through which this dissemination happened. So we cannot say with confidence that this dissemination happened only in Patna and Hazaribagh and not beyond that. So unless, Lord, because after the leak has happened, the question paper is so that there is sufficient time, even if the leak has happened on 5th. Then, my lord, this honorable court ultimately, if sustains this examination, will have to record, in my view, a satisfaction on the basis of the material before this honorable court that we are able to segregate tainted from the untainted, and this satisfaction. This
तरीके से बनाया गया, किस तरीके से लीक हुआ था, किस तरीके से एंट्री कॉपी निकाली गई, उपयोग किए गए सॉल्व कराया गया, फिर उसे पटना होम दिया गया, लाभार्थी इंतजार कर रहे थे, उनको सूत्र रखवाए गए और फिर आगे एसटी का ये मामला था, नहीं हुआ है, वो एग्जाम के हुआ है, इसका बहुत ज़्यादा इम्पैक्ट नहीं है। दूसरे भी जो एलिगेशन थे उसके एक एक करके जवाब दिए। इसके बाद फिर से जो स्टेटमेंट होती सुना गया और उन्हीं से अपना वक्त रखा दी गई कि जब इस लीग का मुख्य पकड़ा गया है और का केस रिपोर्ट हुई है, तो ऐसे में हम यह नहीं जान सकते कि इसके लाभार्थी कितने हैं और भी कई सारी बातें हुई, लेकिन हम उसके बारे में बात करने का फायदा नहीं है। जब फाइनल डिसीजन है वो आ चुका है, रीनीट नहीं होगा। 2015 में दिया गया था, उसके आधार पर भी यह डिमांड की गई कि जब 6 लाख से 44 मामले लाभार्थी पकड़े गए थे तो रीनीट कंडक्ट कराया गया था। ऑफिस में खुद सरकार का मानना है कि जैसे कैंडिडेट्स हैं जो स्कैम में इन्वॉल्व है वो ऐसे में रीनीट कराने लग जाएंगे, लेकिन फाइनल डिसीजन आया वो यही रीनीट नहीं होगा। सभी लोग रीनीट की डिमांड कर रहे हैं।
Admittedly planning 2-3 months before by a gang. CBI officer specifically used very cautiously the word that so far we have not gone beyond Patna and Hazaribagh. CBI is not so